practice before the students of the University of Pennsylvania. He says, it's been alleged that grand juries are confirmed. All right, so, anyways, they made me try Hale versus Hankel again, effectively, but versus scrub nuts over here, and I won, and that's Hale versus Hankel, 1906. What is this? Raffle! I love it. I'm all making fucking stupid demands. This is so funny. What the hell? Wow, I am a flippin' weirdo. So, anyways, boop, 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 boom. I'm totally really lame. It's really funny. Yeah, I'm dealing with post-stress issues a lot. Yeah, and that was back in 17. At least I was, at least I was lively. What's all this crap? Writ of habeas corpus is not a written of error, and the order is to be entered therein as for a discharge or a remand to custody. If a discharge is ordered, no punishment can be inflicted under the judgment. Alright, anyways, I'm authorized to say that the Chief Justice concerns. Alright, so look at this. This is really interesting how the goes to the dog Latin. So, the order of the circuit court should be reversed, and the case remanded with instructions to discharge the petitioner, leaving the grand jury the right to initiate new proceedings not subject to the objections to this. I am authorized to say that the Chief Justice concurs in these views. Official Supreme Court cases only found print version of the United States reports. Justice case law is provided for general informational purposes only and may not reflect current legal developments, verdicts, or settlements. We make no warranties or guarantees about the accuracy, completeness, or adequacy of the information contained on this site or information linked to from this site. Wow. This is alright, so writ of habeas corpus is not a writ of error, and the order is to be entered therein is for a discharge or a remand to custody. If a discharge is ordered, no punishment can be inflicted under the judgment is rendered, and if a new prosecution is instituted containing the good count, a plea of former conviction will be a full defense. But in the case at bar, an order for a discharge will have no such result. The habeas corpus statute provides that the court or justice or judge shall proceed in a summary way to dispose of the party as law and justice require. Justice requires that he should not be subjected to the costs of this habeas corpus proceeding or be punished for contempt when he was fully justified in disregarding the principal demand made upon him. The order of the circuit court should be reversed, and the case remanded with instructions to discharge the petitioner, leaving the grand jury the right to initiate new proceedings not subject to the objections of this. Interesting. Oh, and this is 1906. Hale versus Hankel, 1906. So there you go. Just a little bit different. Yeah. Government does not give Congress any right of visitation of any power to dispense with the immunities and protection of the Fourth and Fifth Amendments. The national government has jurisdiction over crimes committed within its special territorial limits. Can it dispense in such cases with these immunities and protections? No more can it do so in respect to the acts and conduct of individuals coming within its regulating power. It has the same control over commerce with foreign nations as over that between the states. It arose under the Revenue Acts, and the applicability of the Fourth and Fifth Amendments was sustained. In that case is an elaborate opinion by Mr. Justice Bradley, speaking for the court, in which the origin of the Fourth and Fifth Amendments is discussed, the relationship to each other shown, the necessity of a consent adherence to the underlying thought of protection expressed in them, strenuously insisted upon. Huh. I love this. That's rad. It's like, you should construe the Constitution to give life and liberty, and if we can't touch it because it's constitutional, well, that's the fucking basis of the whole thing. Awesome. It's very honest about their fucking commercial position. I appreciate that. Close interval construction of some of their efficacy means gradual deprecation or depreciation of the right. Is the initiatory step in the proceedings before the grand jury against this petitioner. This is a major fact in those proceedings, as is agreed that it is not sustainable. It seems to me that the order adjudicating him in contempt should be set aside, and this notwithstanding that subsequently he improperly refused to answer certain questions. Wow, that's really interesting. I had a really interesting case. Alright, so anyways, there's more stuff. Is this the one? That's the one that shows that I'm unique still. What did I do with? I know where the real one is, but where's my copy? So I registered, check this out. I registered the trust with the Federal Reserve. That's funny. Yeah, I registered this thing and everything. How lame. This is where it just says I'm still unique. This is the booty one. But anyways, boom, once again, all the intangible values. All of it. Same with respect, private or corporations are, in law, for civil purposes, deemed persons is unquestionable. A citation from Jews establishes that they are so deemed within the purview of penal statutes. Lord Coke, there, in commenting on the statute of 31 Elizabeth, 7, whatever, respecting the erection of cottages, where the word is used, no person shall, etc., says, this extends as well to persons political and incorporate as to natural persons whatsoever. Neither does the fact that a corporation is engaged in the interstate commerce in any manner bridge the protection and applicable immunities accorded by the amendments. The corporation, of which the petitioner was an officer, was chartered by a state, and over it the general government has no more control than over an individual citizen of that state. Its power to regulate commerce does not carry with it a right to dispense with the 4th and 5th Amendments, to unreasonably search or siege the papers of an individual or corporation engaged in such commerce, or deprive him or her of any immunity or protection secured by either amendment. It is true that there is a power of supervision and inspection of the inside workings of a corporation, but that belongs to the creator of the corporation. If a state has chartered it, the power is lodged in the state. If the nation, then in the nation, and it cannot be exercised by any other authority. It is in the nature of the power of whatever I can't say without totally fucking up. Visitation. Whatever. Amazon corporations, 9th ed. It also says to render the charters or constitutions, ordinances, and bylaws of corporations a perfect obligation, and generally to maintain their peace and good government. These bodies are subject to visitation, or in other words, to the inspection and control of tribunals recognized by laws of the land. Civil corporations are visited by the government itself through the medium of the courts of justice, but the internal affairs of ecclesiastical and eleemosynary corporations are in general inspected and controlled by a private visitor. In this country, where there is no individual founder or donor, the legislature are the visitors of all corporations founded by them for public purposes and may direct. So anyways, did some pretty cool shit. It's a lot of freedom of speech. A lot of freedom mumbling on my part. So, anyways, thought you guys would be into that. Pretty relevant. Oh,